Okay, this is, let's see, part 7 of the video Jewish Racism in the Federal Court. Alright, so finally a handicapped Muslim girl with a paraprofessional assigned to take notes for her in class complains I teach about the history of Islamic conquest. She specifically complains about the topic of Islamic jihad and the enslavement of captives for harems and work slaves, and the practice of Muslims in the Pakistan area where non-Muslim children were taken from conquered lands and trained as soldiers for further jihad conquests. As a quick response, I didn't say what I was accused of in the manner that I was charged, and if the principal bothered to get statements from the entire class that was present for the classes that these were supposedly said, the other kids who would have submitted statements, it would have been greatly different from what I was charged with. The fact is, the principal was selective, and we all know why. She wanted to get me out, and that was it. Didn't care what really happened. So anyway, I should note that I had to go and bring an action in New York State, an Article 78 proceeding, to get an administrative hearing on my placement on the ineligible list. So I had to go through a whole court proceeding, pay for it, file it, go to court a few times before they actually gave me, actually charged me and gave me a Circular 31 hearing. Alright, so after I bring the first Article 78 hearing in New York State Court, a Circular 1 hearing is brought. That's an administrative hearing at the Department of Education. A Circular 31 hearing is a complete farce. You can hear it in my other video, my first video that I presented, where you can hear New York City Board of Education staff attorney Denise Torres talk about how maybe one teacher in 5 years had won at a Circular 31 hearing. Let's see. At the hearing, Denise Torres actually went into hysterics. Quote, "How dare you teach about religion in the class?" And she, end quote, and how I was not allowed to teach about religion in class, and how, quote, "how dare I discuss gay marriage in class," end quote. I will eventually post Denise Torres' theatrics for all to hear in another video, a short clip. Just a quick note before the New York State Bar standards were greatly reduced in July of 1987. You just didn't get attorneys of the caliber of Denise Torres. Anyway, continuing, note, you should realize that discussions in social studies center around topics of the economic, political, and social. Gay marriage and the family unit is social, it's political. Religion, especially in the discussion of something like the Crusades or Islamic history, it's all three topics. In 1999, there were around 2 states that were in the process of instituting either same-sex marriage or civil unions. In 1999 was also a year and a half prior to the Islamic extremists terrorist attacks on our country on September 11th, 2001. Same-sex marriage is a reality, and it's something people in our society have to deal with. You meet people your neighbors, people you work with. I'm not the first person to come up with this. New York City Board of Education, with books like Heather Has Two Mommies and Daddy Has a New Roommate. Why, that was part of the kindergarten curriculum over a decade before I began teaching. Students also have to understand they live in a world where a lot of people, not just dopes, take their religion seriously. And in this country and in other societies in the world, they also have to understand that some of these people who act on their religious beliefs have beliefs different from others in their religion that are much different, much more radical. Just as the Inquisitions, the witch burnings, crusades, the intra-religious wars in Europe are part of Christian history, the religious jihad, conquest, and enslavement are also part of Islam's history. Maybe if our government leaders in the Clinton and Bush administrations were more knowledgeable of the world, the September 11th terrorist attacks might have been averted. So added to the charges in the complaints from over 2 years prior, which were never brought originally to fire me, are one, discussions on gay marriage. I allegedly said gays are disgusting. 2, in discussing religious impact, I allegedly say non-Christians are going to hell and Muslims kidnapped kids. And 3, I allegedly say a woman's place is in the kitchen. In addition, an additional charge of corporal punishment is added. To make ends meet during my termination, I took jobs substitute teaching at various New York City public schools, middle schools, while substitute teaching at middle school in Brooklyn, where Lynn Pagano was principal. In the last period, the 13 and 14-year-olds decided to throw books and roughhouse. The class phone in the office had previously had its innards ripped open before I got there. A 13-year-old Hispanic boy grabbed a black girl who was taunting him, and he was trying to throw the girl over his leg in front of him. In order to keep the girl from being hurt, I grabbed the boy from behind by his arms and wrists, and I ordered him to let the girl go. After a few moments of refusal, the boy finally did let the girl go, but he proceeded to pursue the girl while I held on to his wrist. He lunged for her. He loudly demanded I let go of his wrist, and I demanded he sit down. I refused to let go of him. He kept lunging for the girl. With the class watching, he got embarrassed, and he loudly announced he was going to tell the principal on me, and I told him, go ahead. Eventually he sat down, and I let go. Saw a teacher in the hall. I summoned the teacher in to help me keep order in the class. Turns out the kid and one of his friends complained to the principal, Lynn Pagano. In a few unsworn sentences, the 13-year-old wrote, I twisted his wrist and whispered in his ear I was going to, quote, do something to him outside after school, end quote. His friend in a few unsworn sentences wrote, I twisted the 13-year-old's wrists and whispered something in his ear. There were around 20 other students in the class at this time. Lynn Pagano's initial report to the New York City Board of Education on that date, on November 17th, 2000, she indicated, quote, no injury, end quote. Lynn Pagano on November 20th backdated a letter to November 17th indicating a request to put me on the ineligible teaching list. The letter is backdated because she refers to an 8420 form, and that wasn't filled out because it was dated on November 20th. Let's see. I last worked as a teacher, substituting on November 27th in 2000. It was not until November 28th, 2000 that I was on that the ineligible inquiry list letter was sent to me. No reason was given for my placement on the list. Anyway, at the Circular 31 hearing, which is a foregone conclusion, testifying were Principal Friedman, the Jewish teacher Goldring, even though she never witnessed any of my classes, and Principal Pagano. Not one student testified against me. Only the unsworn writings of the minor students were presented. Principal Pagano suddenly recalled the 13-year-old student's wrist was red and swollen, even though the original report indicates no injury, and even though the November 20th 2000 Form 88420 report only indicates as an afterthought redness to the wrist. No student, just so you know, no student has ever been testified to compel on behalf of a teacher because there is no subpoena power. Past practice of the New York City Board of Education was to bring students to such a hearing was to send a limo to the student's neighborhood where the student and friends would be taken to a fast food restaurant and fed on the taxpayer bill, and then the student would be brought to the hearing. I couldn't even find out who I could get to testify on my behalf, since the records of students are confidential. I'm convicted of all counts. No surprise, because it's a Circular 31 hearing, and nobody wins. I filed a discrimination lawsuit in federal court. The magistrate assigned to the case is Marilyn Dolan Go. She is an ethnic or part ethnic East Asian. She prides herself on being a freedom writer during the 1960s. She was part of a panel in New York State that exposed the racial imbalance of judges in New York State, including the supposed lack of Asians. For her efforts, she was awarded position as a federal magistrate. She is very concerned about what she perceives as discrimination against Asian Americans, especially in the legal field. She volunteers her time to be on the Thomas Tang Moot Court competition, a competition that is geared to seek out Asian law students to compete. Though every law school has some sort of moot court competition, it is evident to that people like Magistrate Go feel that those competitions do not treat ethnic Asians fairly. As she was also active in the Asian American Legal Defense Fund. In the litigation, it takes years for me to discover through discovery what is ordinarily granted in discrimination case. Although the New York City Board of Education has a record of all applications on file at the Board of Education headquarters of all certified social studies teachers and a notation as to each person's race, and although I finally get a record of the numerous uncertified blacks and Hispanic social studies teachers that were hired in locations where I was unsuccessful in seeking a position as a middle school social studies teacher, Magistrate Go denies me the records of the white certified social studies teachers with applications on file to be teachers because, according to Magistrate Go, it would be speculative to assume teachers would actually want a job teaching social studies in the New York City school system just because they filed an application to teach social studies in the New York City public school system. Think about that logic. When I find in other data I am provided the consecutive nature of assigned teacher file numbers indicate white teachers have application on file for semesters and years at the New York City Board of Education prior to being hired at their public schools in New York City, the Magistrate Go grudgingly agrees to release some records. When I am proven correct, Magistrate Go rules the evidence is irrelevant because, according to her, those New York City public school teachers who actually applied for a job a semester or two or maybe years prior to finally being employed as New York City teachers did not necessarily mean those teachers actually wanted a job when they applied. That is according to one of the best Asian legal minds our country has to offer. If Magistrate Go is one of the best and brightest Asians, maybe there's a valid reason why ethnic Asians are supposedly underrepresented in judge